morning. The Senate Judiciary Committee will come to order. Committee today and Monday, and those of you following along in the committee meeting room and online, today and Monday are our last 2 days before what's called legislative turnaround for us to work and pass out of committee Senate bills that have not that are not exempt Senate bills. So we did have on the calendar a hearing today on Senate Bill 466, which is an exempt bill, and we can hear that after turnaround. And so given the time constraints of legislative turnaround, it's important that we are able to send bills out of committee that committee wants to have then sent to the Senate as a whole. So with that, we are going to turn to, and I wanted to make one more announcement that today committee assistant will be sending minutes to the committee members to take a look at and have any suggested revisions ready for Monday. Monday is the last time Senate Judiciary Committee will be meeting until after turnaround. So be ready, please, committee members, to approve or have changes ready to committee minutes that you'll be receiving. So we have a couple of bills that we heard this week in particular, so they'll be fresh in your mind, and wanted to pull up one of those now. Committee, the first bill that we will be working today is Senate Bill 457. It's a piece of legislation that's requiring a waiver of extradition proceedings as a condition of bond. So we heard testimony on that this week from the Johnson County Sheriff's Office, and with that we will have just a short bill brief, if we could, from the reviser. It's kind of a technical piece of legislation. If we could have that, Mr. Thompson.
Thank you, Madam Chair. Jason Thompson, Revisor's Office. So, as you mentioned, SB 457, you heard just 2 days ago. It was introduced or requested by the Johnson County Sheriff's Office, and they provided testimony in favor. Essentially, it just amends a criminal procedure statute concerning release and bond prior to trial to include a provision that shall be in every bond release that the person will waive extradition to Kansas and waive all procedures related to that if they're arrested in another state while they're out on bond, and acknowledge that they are not entitled to release prior to trial in any other state pending that extradition. So it essentially facilitates extradition of someone who violates their bond while they're not in Kansas.
Thank you. Committee, any questions for the reviser? Seeing none, then, do we have any amendments or a motion on the bill? And yes, Senator Baumgardner.
Thank you, Madam Chair. I do not have an amendment, but I would say that I do know that throughout the eastern border of the state, this is an issue that all of the communities seem to be dealing with. So I move that we pass Senate Bill 457 out favorably for passage.
Thank you. Committee, second, Senator Corson. Thank you. Committee discussion on the motion. I agree that especially in our border communities, this is an issue that our law enforcement has been dealing with, and we need appropriate tools to address the situation. So we're glad to see that this bill has a motion before us. You all have heard the motion. All in favor signify by saying aye. Those opposed, no. The motion passes. Thank you, committee. The next bill that we will be working is Senate Bill 483. Again, that was a bill that we heard this week as well, increasing the criminal penalties for theft and criminal damage to property involving remote service units such as automated cash dispensing machines and automated teller machines. We will ask for a bill brief from the reviser, Mr. Thompson.
Thank you again, Madam Chair. As you mentioned, SB 483 is a bill you heard earlier this week. It was requested by the Kansas Bankers Association, and you received testimony from them and some other interested parties, I believe the Credit Union Association, and maybe some others. Essentially, it amends two criminal statutes, one, the crime of theft, and the other, the crime of criminal damage to property. In theft, the amendment is to define the value when the property that is stolen is a remote service unit, which includes ATMs and things like that. It defines value to include the cost of restoring the site of the theft to its condition at the time immediately prior to the theft, whichever is greater, that or the actual value. This is to treat it kind of like we treat scrap metal in that same statute. So the value may be greater than just the value of the property, and thus the penalties would also be greater for that theft. And then the amendments to criminal damage to property would say that if the damage exceeds $5,000, that is aggravated criminal damage to property. And similarly, as part of the value calculation, you can include the cost of repair, replacement, et cetera, of everything that was damaged. So you're more likely to get the higher penalty for aggravated criminal damage with these amendments rather than the normal penalty for criminal damage.
Thank you. Committee questions for the reviser? Seeing none, is there any discussion or amendments on the bill? Senator Gossage.
Madam Chair, I think this bill just makes sense. I mean, this is not just scrap metal. There could be, tens of thousands of dollars in there as well as that. And I think combining all of the different penalties just makes sense. And I stand in support of this and will move that we pass, if it's appropriate at this time, that we pass Senate Bill 483 out of committee favorably.
Thank you. Is there a second? Yes, Senator Baumgardner.
I second the motion.
Thank you. Committee, you've heard the motion. Any discussion on the motion? All right, then. You've heard the motion. All those in favor signify by saying aye. All those opposed, no. The motion passes. Thank you, committee. The next bill that we will work is Senate Bill 497. Again, a bill that we heard this week, brought to us by the Office of Attorney General, authorizing the Attorney General to coordinate training regarding a multidisciplinary team approach to intervention in reports involving alleged human trafficking for law enforcement agencies. And we'll ask for a bill brief then from the reviser, Mr. Thompson.
Thank you again, Madam Chair. As you mentioned, SB 497 heard earlier this week, brought to you by the Attorney General's office, and they offer testimony and support among other proponents. This would amend a current statute that requires the Attorney General to consult with other appropriate agencies and coordinate training regarding human trafficking. This would expand that duty to give a policy statement about coordinated multidisciplinary team approach to intervention and reports for law enforcement, and also echo that sort of sentiment, multidisciplinary team approach to intervention involving these cases of alleged human trafficking and related crimes for law enforcement agencies to be trained on these appropriately and ready to respond. And then the new requirement that's added in subsection C, sort of the second half of the bill, is that each year, a list of persons in the bill are going to be required to complete an hour of training on human trafficking awareness and identification that the AG will develop or approve. And that includes employees or contractors of several agencies who have regular contact with members of the general public, some licensed mental health professionals and counselors, all teachers, school administrators, and employees of educational institutions, and all persons licensed by the Secretary of Health and Environment to provide child care services and their employees. So all of those folks would be required to complete this hour of training that would be developed and approved by the Attorney General. And I just handed the chairperson a moment ago a potential amendment that our office would ask you to consider. We noticed in reviewing the bill that our description of the licensed psychologists and all the counselors in subsection C2 may not have been the most accurate description. We might have left some folks out inadvertently. And so we have a suggestion that would broaden that to include all folks licensed or certified or otherwise authorized to practice by the Behavioral Sciences Regulatory Board, which would encompass all of those folks and a couple we inadvertently left out. So if the committee would be willing to consider that amendment, I've provided that, and we'd be happy to hand out copies at the appropriate time.
Thank you, Mr. Thompson. Committee questions for the reviser. We'll go ahead and ask the reviser to hand out that, what I would consider a technical amendment, cleaning up the language regarding persons authorized to practice by the Behavioral Sciences Regulatory Board as being included in the bill. And we'll ask for further explanation of the amendment by the reviser, Mr. Thompson.
Thank you, Madam Chair. And again, I would couch this as just kind of an oversight in the drafting. You may recall from testimony that the Attorney General's office mentioned that they lifted a list from the mandatory reporter statute that's under the Child Native Care Code. And that list, I think, unfortunately, is a little bit out of date. So in our review and making the bill brief and hearing the testimony, we realized we may have left out, for example, master's level social workers. That was one example that was given to me that we kind of inadvertently left out of this list. So I've been assured by our technical experts on this one, including Ms. Moyer, who is my backup on this committee, that broadening it to the Behavioral Sciences Regulatory Board would catch all of these folks and a couple more that the proponents intended to capture. So.
Thank you. Yes, we have a comment from our IT person.
Yes, Madam Chair, we have a question from Senator Haley on WebEx.
Committee, the rules of the committee are that you have to be in the Capitol on WebEx to participate in asking questions. So I'll ask if Senator Haley is in the Capitol.
No, I'm not.
Okay, thank you. Then committee, you have the amendment in front of you. Do we have any questions for the reviser? Senator Baumgartner.
Thank you, Madam Chair, and I apologize to the reviser because this question isn't directly with the amendment, but it is with what follows the amendment, and that would be under Section 3, all teachers, school administrators, and employees of educational institutions. And the reason I ask this is because an issue came up last night at a Board of Trustees meeting. When we indicate teachers, school administrators, and employees of educational institutions, that really sounds more like the descriptor for K through 12. And the question has come up with regard to our community colleges and technical colleges, and even some of our Regents institutions that provide concurrent enrollment opportunities for high school students. So, a point of clarification, do we feel this includes higher education institutions, specifically faculty members, or is that something that might need to be amended just as we did using the appropriate vernacular in the Bloom Amendment already here?
That's a question for the reviser. Is that something you can answer, Mr. Thompson?
Madam Chair, Jason Thompson, Revisor's Office. So, as I mentioned, this list is drawn from the Abuse and Neglect Reporting Statute. And I'm looking at it right now. It's in 38-2223, if you wanted to see that. But the definitions for that term in 38-2202, it's all schools at the elementary and secondary levels. So, depending on how you wanted to go here, we could either say as defined in 382202, just to make the definition clear. Or we could say, at any educational institution at the elementary and secondary level, or if you wanted it to cover broader than just K through 12, we would need to consider some wording that would broaden it a little bit further. So it kind of depends on which policy you want to pursue.
Thank you. Senator Baumgartner.
Thank you, Madam Chair. I do think it's an issue that I don't want us to try and cobble this together right now while we're working on this amendment. But the concern I do have is, the reports are out now that some of our technical colleges have as many as 25% of their enrollment are actually high school students. Community colleges historically are right at 20% of their enrollment is high school students. A good portion of that is either SB 155, the Excel students, or students that are receiving concurrent enrollment. So as we continue to kind of blur the lines of where that oversight is of K through 12, because we know that is being delivered by higher education faculty. So perhaps that's something that we can address, a friendly balloon amendment when this is on the floor. I don't see that we can do this now, and didn't occur to me, except for it was a discussion item last night at a Board of Trustees meeting.
Thank you. I'll ask the reviser, would it be appropriate if we need additional time to prepare an amendment to suspend working the bill procedurally?
Madam Chair, Jason Thompson again. As far as I know, you do not currently have any motions pending. We were just having discussion, so it's completely appropriate and in your discretion.
Well, with that, then we will, since we don't have a motion before us, we will end for today our discussion on Senate Bill 497 to allow some additional time for amendment on Monday, because this is a non-exempt bill and would need to be addressed Monday if we're going to work on that. Yes, Senator Baumgartner.
Madam Chair, I will work with our reviser to have that for us so that we can work this and get this bill up and out. I'm absolutely in support of this bill, but I do want us to find the proper balance to make sure that all of those that are educating our kids at that K through 12 level have that training. So thank you.
Thank you. Committee, then we have next a bill that we heard last session. It brings Kansas law more into consistency with some other practices. And it's Senate Bill 141 regarding enacting the Kansas Uniform Directed Trust Act. So it's a bill that doesn't involve the criminal statutes, but is a bill that has been brought to us by the Kansas Judicial Council and been studied by the council, and it's their recommendation that we take a look at this. So with that, if our reviser is ready for a bill brief, it's a rather lengthy piece of legislation, and I believe in your committee folders then we do have the Senate Bill 141 information, if you'll look in your committee packet. And with that, then we will ask the reviser, Mr. Thompson, for a bill brief.
All right. Thank you again, Madam Chair. Jason Thompson, Revisor's Office. So Senate Bill 141 was heard February of 2021. It does enact the Kansas Uniform Directed Trust Act. I won't go through the couple-page bill brief there, but I will highlight that a directed trust is defined in Section 2 to give you an idea of what we're talking about here. It's a trust for which the terms of the trust grant a power of direction, and a power of direction is defined as power over a trust granted to a person by the terms of the trust to the extent the power is exercisable while the person is not serving as a trustee. but there are certain powers described in Section 5 that are excluded from that. So that caveat is there as well. The dates in this bill are obviously a year old. So I do have a technical amendment ready at the appropriate time that would update us for 2022, including one statute that was amended last year. So we have to strike that statute and replace it with the current version. So at the appropriate time, we can consider that. But the bill states that this would apply to certain trusts created before July 1 of 2021, which probably should be 2022. But it only applies to decisions or actions that occur after the effective date, essentially. So if it was created before the date, it applies to acts, to decisions or actions that take place after. If the principal place of business is changed, principal place of administration of the trust is changed after the effective date, the act would only apply to a decision or action occurring after that date. So there are some principles of which trust this applies to or doesn't apply to. And just to avoid kind of getting into some of the nitty gritty of the details, I'll give you the broader description from the Judicial Council, which I think is a pretty good summary, that this deals with the powers, fiduciary duties, and liabilities of trust directors and directed trustees. So there are broad provisions regarding powers that could be granted to a trust director. It does offer some uniformity in the use of terminology because it is a uniform act. So from state to state, you would have consistency. And they note that it has been adopted in 13 states thus far, including 2 of our neighbors, Nebraska and Colorado. The council stated that the current law does not quite get to clients who want to structure a directed trust with bifurcated trustee powers and duties, and this act would address those circumstances. And then in your packet, you have both their testimony and the Uniform Law Commission summary of what this act deals with, why it's a good policy decision, et cetera. So I'd refer you to that for a little bit more information. And I'd be happy to answer any questions if you have them. But obviously, there's a good 20 sections in this, and I don't want to spend too much time unless you have particular details that you want to get into. And then remind you that we have a date update. If you do want to pass this out, we would recommend you do that technical amendment as well.
Thank you. Committee questions for the revisor? Yes, Senator Gossage.
Thank you, Madam Chair. I guess I'm trying to understand. I know this was brought to us by the Senate Judiciary, by the Kansas Judicial Council. I'm trying to understand the problem that they're trying to solve.
Is that a question the revisor wants to take on, or we have the testimony in your committee packet as a reminder from the Uniform Law Commission, and the Uniform Law Commission takes a look at creating uniformity in certain areas of law, and you'll see that there are a couple of highlights regarding what the proposed law would do. It balances settler autonomy and beneficiary safeguards. It's more comprehensive, and it offers many technical innovations in this field of law. But if the revisor can touch on a couple of those, that would be helpful for the committee. Thank you.
Thank you, Madam Chair. Jason Thompson again. I'll just highlight the paragraph in the Judicial Council testimony that references sort of the inadequacies, as they call them, of current Kansas law. I'm not a trust attorney, and I don't want to be one. This is as much trust and estates and stuff as I will do, thank goodness, hopefully. So the claim is that clients who want to structure a directed trust with bifurcated trustee powers and duties cannot do that adequately under Kansas law. So if you appoint co-trustees with different powers, under the current law, each co-trustee is responsible for and has a duty to monitor the other trustee's actions, right? So you're a co-trustee with someone else, you're responsible for that co-trustee's actions, even though you may have different powers. And the reason for that is because of KSA 58A-703, apparently. So even if my trust is trying to say otherwise, that you have responsibility for X and another trustee has responsibility for Y, both trustees are responsible for X and Y, regardless of what my trust says, because of the statute. The Uniform Act provides sort of the opposite statute. so that if my trust dictates that you have different powers and duties, you're each only responsible for your different powers and duties. So it allows for that sort of direction, bifurcation, et cetera, to individual persons with different duties in the trust. And from what the conferees were stating, this is just something that some folks would like to have the option. The current law in Kansas doesn't really support it, but the uniform law does. And then they would also have that clarity and that uniformity that the trust lawyers are seeking kind of throughout the states, and bringing that to Kansas. So those are the two main reasons they gave.
So clearly a policy choice. Does Kansas want to do this? 13 other states have. So I bring it to the committee to determine if that's something that we would want to pursue in Kansas as well. Senator Gossage.
Thank you, Madam Chair. In reading this and what I hear from our revisor is it just brings more clarity to the process of having a trust. The only time I've gone through a trust was with my parents' trust and an uncle. So I think that is my limited experience. So I think just having gone through that myself, any kind of clarity I think would be helpful. And it does say technical innovations, giving other options. I would not be opposed to this bill. Thank you.
Thank you. Senator Pyle.
Yeah, I'm just curious. I'm looking at the fiscal note from the budget director and the last paragraph where it says that the Office of Judicial Administration indicates enactment of the bill could increase the number of cases filed in district court because it creates a new type of trust and is expected to result in various legal actions. This would increase the time spent by court employees and judges processing and hearing cases. And I assume that's at district level. The office indicates enactment of the bill could result in a collection of additional docket fees for those cases. I just, with the workload, I noticed in the testimony we did not hear from the District Judges Association. So just kind of hesitant. Thank you.
Thank you. Question for the revisor. Is this something that without Senate Bill 141, if Senate Bill 141 isn't enacted into law, could a settler of a trust create this bifurcation by direction in the trust without this becoming law? Kind of with the current state of law, if you wanted to set up a trust and state that this co-trustee has this power and authority and not responsible for what the power and exercise of that power and authority by the other co-trustee, could you go ahead and direct and separate that without Senate Bill 141?
Thank you, Madam Chair. Jason Thompson again. So I was just looking at the statute cited by the Judicial Council testimony, KSA 58A-703, which is part of I'm pretty sure that's the Uniform Trust Code, if I'm not mistaken. That deals with co-trustees, and essentially each trustee has a duty to prevent the other co-trustee from committing a breach of trust, and also has a duty to compel them to redress a breach of trust. So the argument I see them making is that even if my trust attempts to give each person different duties and different powers, they each become responsible for the other co-trustee, and that can potentially cause a problem. That's what the trust lawyers are saying, is that you can try to set these up, but if you have certain trustees that you're trying to give this kind of directed power to, now remember this is a distinct class of powers, right? That definition of power of direction. So if you're trying to give someone a power that is limited, and then you're trying to give another co-trustee a different power, they all kind of become responsible for each other under the way the current law is, at least according to the folks who practice in this area. Excuse me. So their direct statement was, without this act, without the UDTA, Kansas law is inadequate to support clients who want to structure a directed trust with bifurcated trustee powers and duties. And then they sort of expanded on that with the responsibility that's shared. So you're correct that it is completely a policy choice, right? there could be some benefits and disadvantages to these kinds of trusts. If you wanted to make one under current law, you're not able to maybe do all the things that you would like to do, or that the trust lawyers think they would like to do to make that work the way you want. And this act would allow that to happen. But as Senator Pyle pointed out, the courts recognize this would be a new kind of trust that would bring something new to the table in Kansas, and so whether you're willing to do that or not is the policy question that you're asked. But I don't believe you can do some of these things under current law, and this would allow you to do a couple of things that you can't right now.
Would the allowance of the new things, would that apply to trusts that are in existence at the time this bill would become law? Would it apply retroactively to the trusts that are in existence when this, if it becomes law, becomes effective?
Okay, so Madam Chair, I'm looking at page 2, line 17, so that new section 3. This Uniform Act applies to a trust whenever created that has its principal place of administration in this state, subject to the 2 rules there. 1, if it was created before the effective date, which as I'm indicating should be updated to 22. This act applies only to a decision or action occurring on or after that date. And then if the principal place of administration is changed to this state after the effective date, this act applies only to a decision or action occurring after the effective date. So yes, it does apply retroactively, but only to the extent that you take the action after this act goes into effect. And as I was trying to state, this is a fairly limited set of actions, right? This is not all trusts. This is not all powers. This is a directed trust, which has a power of direction, and those are both kind of narrowly defined terms. So I don't know that this would apply, for example, to a trust I have or that you have. These are more specialized powers and trusts than probably most of us would have. That's my understanding anyway.
Yes, from our IT person. I'm sorry, I don't know your name. What is your name? I apologize.
Yes, Madam Chair. My name is Dennis Nicholson.
Of course. Thank you, Mr. Nicholson. Go ahead.
Senator Haley has a procedural question for you and for all the members of the committee.
Okay. Senator Haley, what is your procedural question?
Madam Chair, and I'm sorry to interrupt the discussion regarding the bill. I just wanted to ensure that by my count, there are 5 members present physically in the committee, and at least 2 members elsewise, myself elsewise. The concern procedurally is a quorum has to be fixed. And I think it's the necessity of those that are on WebEx. I'm not wishing to vote. I understand the committee rules. But for those of us that do participate in the committee by WebEx, if we have questions regarding pending matters, I would hope that we would be, as we have been able in other committees by WebEx, to at least participate in the pending matter by way of discussion. Thank you.
Thank you. To clarify, we do have a quorum today. We have 5 committee members of 9 who are present in the committee meeting room. So we do constitute a quorum of the committee here today. And thank you for pointing that out. The rules of the committee are the rules of the committee, and we will go ahead and continue to abide by those.
Thank you.
So with that, my question was going to be, after we heard this applies only to directed trusts, with the act, would we be changing, if it becomes law, the trusts that are in existence and were created under a certain set of laws by the settlor of the trust, and changing that as well?
Madam Chair, Jason Thompson again. So I appreciate the clarification. I think the answer is yes, right? So if you did create a directed trust prior to this bill somehow, or you attempted, I suppose, to create a directed trust, and you had co-trustees with powers of direction, as that term is used, you might create a situation where one person may have been responsible for that co-trustee's actions under the current law, but they're not responsible for that other co-trustee's actions under the new law. That's one example they kind of highlighted. But to the extent that the trust defined the powers or duties, I don't think this in any way affects your powers or duties necessarily. It may just affect, so it may affect certain powers of direction that may have been given to you and how those are used. But it shouldn't affect a lot of other trustees. And it only affects actions and decisions that occur after the effective date. So it does affect those instruments, but it doesn't necessarily affect actions that are already taken. I know that's kind of a nuanced lawyer answer, but it's a trust bill, so I have to give one like that because it's always complicated.
Thank you. Committee, we now have four committee members in the committee meeting room, with Senator Pyle having exited the committee meeting room. So I don't know of his intent to return or not. We can stand at ease for a minute or two and see if he returns. And if not, then we will have to adjourn the committee meeting at that time. So we will stand at ease for a minute or two and determine his whereabouts and if it is his intent to return to committee. Thank you. Thank you, committee, and those in the committee meeting room and following along online. We have determined that Senator Pyle is not returning to the committee meeting room, so we do not have a quorum, and so the meeting is adjourned. Thank you all.